if you send it off to the lab, I'm sure you'll see that it's not, I don't do nothing like that. I don't even have the money for that.
Well, all I know is you tested positive for methamphetamine. And obviously there's some concern because you were arrested while this case was pending, and Mr. Coleman figured that out. Hold on.
So it's a traffic ticket.
Just hold on.
I would just observe if it's paraphernalia, that's a class C and normally those aren't arrestable. I mean, it is an arrestable offense, but normally it's just a ticket. So jail or fine on the offense.
Doesn't matter. If you're on bond for a felony, you should. I just asked you not to say anything else right now, okay? I'm just checking on something.
Let her check. This is right.
Obviously, Google and AI is not the end-all be-all, but it is unlikely to cause a positive result on a standard drug test. A 5-hour energy drink does not contain prohibited substance like THC, opiates, or amphetamines. Extremely rare and undetected issues involving cross-contamination during manufacturing would do it, so I don't think that's what we're worried about today. I'm going to grant the state's motion to raise your bond based on the fact that you tested positive, based on the fact that there was an additional arrest while you were on bond for a felony offense. I'm raising your bond in your case. It's currently set at $30,000. I'm going to raise your bond to $75,000. I'm going to order, as a condition of that bond, that you have a drug patch at all times, that you get it changed out as you're supposed to. Your case is still set for trial to begin with jury selection. All right, Ms. Clayton tested negative, which is obviously good, and
No 5-hour energies.
yeah, you never know about those energies.
Stay away from
Ms. Clayton, in cause number 25, DCCR 0446, you were previously in court, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
defense agent.
Yes, Your Honor.
Are there any additions or corrections?
No from defense.
Not from the state, Your Honor.
What is everyone's position with regard to the recommendation in the pre-sentence report with regard to her addiction issues? The recommendation is ISF followed by JCDI program.
Again, from the defense, Your Honor, the treatment is a continuum, I suppose, and since she's demonstrated, at least today, that she's drug-free, then I would suggest the court hold the ISF in advance to just see how she progresses on probation. Maybe perhaps with a drop program.
Well, she's going to go through JCDI for sure. If, at a minimum. Mr. Nichols, thoughts since
I
she
would ask
tested
at least for
negative?
JCBI, Your Honor. She's still underage, but she has a drinking problem and needs to get that dealt with, treated, or under control. And she also smokes marijuana regularly. The facts on this case, she and her friend were heavily intoxicated,
Yeah.
fled from police, lucky it wasn't a crash,
It could have been terrible.
tried to hide out from police around
Yeah,
a...
I know, yeah.
I mean, it could have been a lot worse. And I'll just tell the court from reviewing the video, at least that night, they sure thought it was hilarious. She needs to grow up. She needs to take a little more serious what's getting her here in felony court.
Yeah.
And
You understand it's not funny. I mean,
I'm not going to get
no, I understand that right now, and people do
But
that.
that night, yeah, I do regret everything that night.
So here's the thing, and the seriousness of this is that if you don't do what you're supposed to and get your life on the right track, which is what everyone wants. You're young. We want you to be successful. You're going to get a probation today where you don't have a felony conviction on your record. And if you complete that probation, you're never going to be a convicted felon. But if you violate and you don't take advantage of the programs that we're going to give you, it's going to be difficult because you're at an age where all your friends are going to be doing things that you're not going to be able to do. But the alternative is prison for up to 10 years. So you need to think about that every time somebody says, oh, just come on out with us and do whatever. And your answer is going to be, I'll do that in a few years when I'm not on probation, right? Because I don't want to go to prison for 10 years.
Curfew's important. It's probably one of the most important.
So I am going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $250 fine. I am going to order that you enter and successfully complete the ISF substance abuse track, but I'm going to hold that in abeyance. That is an inpatient 90-day program. So if you get in, you're going to be required to go to JCDI and complete that program. And it'll give you the tools, hopefully, that you need to stay sober. If that's not enough and you need something more, it's already ordered. A warrant will go out for your arrest. You'll go into custody and you'll go straight to that program, okay? I'm handing you the trial court certification that shows this was an agreement that I followed. So you have waived your right to appeal. You just need to have a seat here in the courtroom. Probation will call you up when she's ready to go over your paperwork. Good luck to you, ma'am.
Thank you, Your Honor.
Good morning. Are you Julia Schultz? And Mr. Samuel, your client waived the formal reading of the indictment. Ms. Schultz, in cause number 24, DCCR 2290, you're charged with a first-degree felony offense of injury to a child from August 13th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Samuel?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for a 10-year deferred probation. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation. And are all of the, has the rights to all of the children been terminated? Okay.
Yes.
And you understand that a condition of your probation,
And why I put that little caveat in there, Judge, I know it looks kind of silly. There
No.
are some things that Mr. Samuel and I would like to present at the time of the PSI, and we could maybe do an 11 o'clock sentencing whenever we come back.
Sure.
That day, there are going to be very specific terms and conditions that we are going to request of the court. Possibility of special needs, safety, the absolute requirement that she remain in Jefferson County throughout the duration of probation, et cetera, et cetera. But the rights, she has relinquished her rights. The father's rights have been terminated as
Okay.
well. You allowed us time to do all
Right.
that down in family court.
Right.
And I have a memo from Ms. King as well, that I think would be informational for the court, and I've also discussed it with Mr. Griffin.
okay,
That's our request.
okay. And you understand all of that, correct? All right. Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Schultz is not competent?
There is none.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing. And on your way out of the courtroom today, you need to stop and talk to probation. I also want to make sure you understand, as a condition of your bond right now and as a condition of your probation, it will be that you cannot be around any child alone under the age of 18. I'm not sure medically if you're still able to have children. I want you to understand that if you have another child, I'm not going to allow you to be around that child. So I can't necessarily stop you, I think, legally from having a child. Unfortunately, I feel like in some cases I wish I could, but I can tell you that you won't be able to be around that child. So you need to do what's best for you and any future possible children and not have any. Make sense? All right, stop and talk to probation on your way out of the courtroom. And we'll set that for an 11 o'clock hearing. That's okay. All right, sir. I'll recall, obviously, the bond forfeiture. And so, Mr. Van Wright, you were previously in court and entered pleas of true in a motion to revoke your probation and entered plea of guilty in the new offense. Can you send me that paperwork, just because this is all... And the agreement was for 2 years TDC, and I gave you a little bit of time to come back and be sentenced today, correct? Were you arrested for anything between that time and now? So if they were agreed, I should have these printed out. We shouldn't have these if they were agreed. There they are. Put that away. All right, and give me just a second. Sorry, I'm a little out of sorts. What? Take retreat to.
There's only one count. Press on the power button.
Okay,
The original was not true, and then on December.
and then change it. Got it. All right, Mr. Van Wright, in cause number 24 DCCR 2485, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of injury to a child, elderly, or disabled individual. Sentence you in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 15-23582, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find sufficient evidence in that case to revoke your probation, and at this time, revoke your probation and reassess your punishment in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that for any time that you've been in custody that the law gives you the right to receive. The cases will run concurrently, which means together at the same time. I'm handing you, in each of those cases, trial court certifications that shows that these were agreements that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can speak with your attorneys. All right, good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Simmons. All right, Mr. Harris, this is 24 DCCR 2254. You tested positive this morning for methamphetamines and
I
amphetamines.
drink a lot of 5-hour powers for 3 days, and that's the only thing I think that would make a problem. I've been in Houston with my kids, and I ain't even been around here right now. And I drink a lot of 5-hour powers of red.
5-hour powers is not going to test positive for
You
methamphetamine.
know, if you send it off to the lab, I'm sure you'll see that it's not, I don't do nothing like that. I don't even have the money for that.
Well, all I know is you tested positive for methamphetamine. And obviously there's some concern because you were arrested while this case was pending, and Mr. Coleman figured that out. Hold on.
So it was a traffic ticket.
Just hold on.
I would just observe this, if it's paraphernalia, that's a class C and normally does unarrestable. I mean, it is an arrestable offense, but normally it's just a ticket. So jail or fine on the offense.
Doesn't matter. If you're on bond for a felony, you shouldn't. I just asked you not to say anything else right now, okay? I'm just checking on something.
Let her check this is right.
Obviously, Google and AI is not the end-all be-all, but it is unlikely to cause a positive result on a standard drug test. A 5-hour energy drink does not contain prohibited substance like THC, opiates, or amphetamines. Extremely rare and undetected issues involving cross-contamination during manufacturing would do it, so I don't think that's what we're worried about today. I'm going to grant the state's motion to raise your bond based on the fact that you tested positive, based on the fact that there was an additional arrest while you were on bond for a felony offense. I'm raising your bond in your case. It's currently set at $30,000. I'm going to raise your bond to $75,000. I'm going to order, as a condition of that bond, that you have a drug patch at all times, that you get it changed out as you're supposed to. Your case is still set for trial to begin with jury selection on Monday, and is everybody ready for that?
Yes, Fred.
All right, I'll number the case. If you're in custody, we'll have you brought over for trial. If you're not, then you can talk to Mr. Kimler this morning, okay? All right, you can go back with the bailiff.